Yes, state. Your worship, court is considered before the matter is over for ruling. You are ready to receive it. However, I just wanted to note that counsel have patience court and is on watching brief. And I have patience. You are ready to receive the ruling.
This is the ruling. The accused, Musa Ibrahim, also known as Pressure 24/7, to stand charged with 8 counts. 4 of these 8 counts are for hate speech. Under section 26 up to A1, A, C, and 2 of the Computer Misuse Act of 2011 as amended, where it is alleged that the said accused person between August 2023 and February 2024 in the areas of Kampala district or thereabout, while using a computer via TikTok account at Pressure 24/7, shared information which is likely to ridicule or degrade or demean and promote hostility against the persons, to wit, His Excellency Bakadama Bamuzayo, President of the Republic of Uganda, in count number 1, His Majesty Ronald Mwenda Mutebi II, the Kabaka of Uganda, in count number 2, Right Honorable Anita Monk, the Speaker of Parliament of the Republic of Uganda, in count number 5, and Honorable Joyce Nabosa Sebugwawo, this is in count number 7. Inside with 4 counts of malicious information, called the section 26C, subsection 1 and subsection 2 of the Computer Misuse Act of 2011 as amended. It's alleged that the said accused between the month of August 2023 and February 2024 in the areas of Kampala district or thereabout, while using a computer via TikTok account at Pressure 24/7, shared malicious information relating to the following persons. 1. His Excellency Bakadama Bamuzayo, the President of Uganda, in count number 2. His Majesty Ronald Mwenda Mutebi II, the Kabaka of Uganda, in count number 4. Right Honorable Anita Monk, the Speaker of the Republic of Uganda, in count number 6. And Honorable Joyce Nabosa Sebugwawo, in count number 8. The accused person denied all the 8 counts and applied for bail through 4 advocates, namely Masaba Raphael Gideon, Tumusime Kakulu, Tumusime Kato, and Ochida Hope. The accused presented 2 sureties, namely Numbers of Brenda, age 35, who operates a cosmetic shop and sister of the accused. Ibrahim Sembata Matia, age 32, who operates a phone and accessory shop and friend of the accused person. The state, represented by Land's Chief State Attorney Richard Vumbuka, opposed the application on the following grounds. And based on the affidavit in reply deponed by Detective I.P. Mpamizo Agre, and the grounds are the following. That the applicant or accused person has no fixed place of abode, that the area local council one chairperson of Church Zone in Najana Nkumbi disowned him in the letter annexed C to the affidavit in reply, stating that he has never been a resident of his area. That was arrested from Excelsis Garden Hotel in Ntinda, where he had lived for 2 months, and that the charge sheet has his resident as Kauga in Mukono, and therefore the accused person's residence is not clear, yet it's a key factor to consider in granting bail. The accused has no credibility given the fact that he has no place of abode, that his chances of absconding are high and therefore is a flight risk given that he lacks a fixed place of abode. Inside the case of Francis Onebe versus Uganda, stating that it would be risky for this court to raise an accused person who has no fixed place of abode. It was further the submission of the Land Chief State Attorney that the 2 sureties are not substantial, that Numbers of Brenda, a sister of the accused person, is a tenant at Church Zone without credible source of income, while Mr. Sembata Ibrahim Matia was disowned by the area chairperson of Muzana Zone in Kisenyi, where he allegedly stays. He concluded that the two accused person, that the 2 sureties have no fixed places of abode, and that Numbers of being a tenant can shift any time, and on credible sources of income. He cited the case of Mugera John versus Uganda. He further stated that the case is of public interest, and he cited the ruling of Justice Tibulia in the consolidated Minister's application 45, 46, and 47 of 2015. It was further the state's submission that the accused will be unsafe outside prison and that the offense is grave in nature. He prayed that bail will be denied, and that if this court is inclined to grant bail, it should impose extremely stringent bail conditions. In rejoinder, Mr. Masaba submitted that the offense is not of grave in nature as alleged by the state, as attracts a maximum sentence of 5 years in prison upon conviction. That the AIO's chairpersons who disowned the applicant and the sureties were intimidated by the investigating officer. That the state order has enough evidence against the accused person, and that's why they will charge him in court, and that therefore the accused person shall not interfere with the investigations. It was a submission that the sureties are substantial and that numbers of being a tenant cannot bar her from being a competent surety as long as she can ensure that the accused person attends trial. You confirm that the accused has a fixed place of abode at Church Zone and in Kkoti, where he stays during holidays with his mother. You pray that the court releases the accused person on very lenient terms, particularly on non-cash bail. The issue now before this court is whether or not the accused person has satisfied the ground for release on bail. It's straight law that every accused person has a constitutional right to apply for bail, which court has discretion to grant or not to grant in accordance with the law. I have carefully addressed my mind to paragraph 13 of the Constitution, Bail Guidelines for Courts of Judicature, Practice Direction of 2022, particularly paragraph 13 on consideration for grant of bail. The same paragraph states that the court shall consider the following in handling a bail application. 1. The gravity of the offense. B. The nature of the offense. C. The antecedents of the applicant insofar as they are known. D. The possibility of a substantial delay of the trial. E. The applicant's age, physical and mental conditions. F. The likelihood of the applicant to attend court. G. The stage of proceedings. H. The likelihood of the applicant to commit another offense while on bail. J. The safety of the applicant, the community, and the complainants. K. Whether the applicant has a fixed place of abode within Uganda, or whether he or she is ordinary resident outside Uganda. L. Whether the applicant has sufficient sureties within Uganda to undertake that the applicant shall comply with the conditions of his or her bail, among others. I note that the residence of the applicant is not clear. The charge sheet has his residence as Gauka Mukono, and when the charges were read to him, he never denied this particular fact. The letter introducing him came from Church Zone in Najanankumbi, whose chairperson LC1 has since disowned the said accused person as case said that not a resident of the area. There is also another letter from Kkoti Nibudaka where they allege that he stayed with mother during holidays. According to the police, he was arrested from a hotel in Ntinda where he had stayed for 2 months. In light of paragraph 13(1)(k) of the bail guidelines, I don't find the accused person to have a fixed place of abode. The evidence on record shows that he stays in Church Zone, Kauga in Mukono, Kkoti Nibudaka, and the hotel in Ntinda. Paragraph 15(1) of the bail guidelines sets out what court has to consider in finding surety substantial, and these include the age of the surety, work and residence address of the sureties, surety numbers of Brenda as a place of work and residence at Church Zone, and Martha, she is a tenant. She is also a sister of the accused person. In light of paragraph 15(1) A and E of the bail guidelines, I find her substantial. However, suite number 2, Mr. Sembatia Ibrahim Matia, has no clear place of residence, as he was disowned by the area chairperson of the zone where he alleges to be staying. He has no clear relationship with the accused person. A male sister is his friend. And in light of paragraph 15(1) B and E of the bail guidelines, I don't find Mr. Sembatia Ibrahim Matia a substantial surety to stand for the accused person. An applicant who has no fixed place of abode and without substantial sureties cannot be released on bail. If court did so, it would assume a risk as stated in the case of Francis Onebe versus Uganda, which was cited above. I am not ready to assume this risk for the reasons stated above, and for those reasons I do reject the bail application and further remand the accused the 26th of March 2024 when the case shall come up for mention. Another file.
Criminal case number 480. Criminal case.
What is that? It's coming up with.
Come up today.
Are you sure? Are you sure? Are you looking at that similar? Just wait there.